Okay, well, thanks everybody for being here. I'm Ken Rother. This particular event is sort of brought to you by Rev, so to speak. I'm the director of Rev, and today we have a presentation and a chance for Q&A on intellectual property, which is a super broad topic. People think of intellectual property as just patents, and it includes a whole lot more than that. Patents in themselves are complicated, but there's trademark and there's copyright and trade secrets and various other documents. So it's a big, broad topic, and we're fortunate enough today to have the team, not just an individual, but the team from Klausner Cook, to do a short presentation and then take questions. And again, as Sarah just said, you can ask questions by putting them in that Q&A, and we'll keep an eye on what's going on there. But I think I will just pass it over to Nate and his team to introduce themselves and to get going.
Well, thanks, Ken, and hey, everybody. It's great to be here today. Really looking forward to talking with you. And as Sarah mentioned, please put your questions into the Q&A. We're gonna try to take them on the fly, and so don't feel bad about interrupting. We want to try to make this as interactive as we can. So as Ken said, my name's Nate Cook. I'm one of the founders of Klausner Cook here in Ithaca, and also in Rochester. I'm joined with two of my colleagues, Alex and Luis today, and we're going to talk about some of the types of IP that Ken mentioned, and really looking forward to the presentation. Wanted to mention that although we'll be talking a lot about sort of different concepts within the world of IP, we're not necessarily giving you legal representation or that kind of thing. If you want to talk offline or raise particular issues, we're happy to do that as a side matter. Just to kind of frame the discussion today, right? One of the big challenges that inventors have is, they want to discuss their ideas with all sorts of different people. There could be partners, investors, there's, vendors, competitors. And how do you think about how to talk about your ideas while keeping them protected? That's kind of the theme of the day. And what our firm basically is dedicated to, sort of the mission of our firm is to help people start and grow their businesses. And IP is a huge component of a lot of high growth technology companies. And the time to really start thinking about that is really at the inception of sort of both the invention and the formation of the corporation. And so, IP has been sort of recognized in this country since the very, very beginning. And, if you're familiar with the Constitution, Article 1, Section 8, that really falls under sort of Congress. And so there's this statement that, to promote the progress of science and the useful arts by securing for limited times to authors, inventors, the exclusive right to their respective writings and discoveries. That statement that is really the genesis of both patent and copyright law. And so, when we talk about, inventors and discoveries, that's like, patents, and then writings is really copyright law. And so, as we think about these things, that one simple statement, is the beginning of a very complicated area of the law that recognizes lots of different things. And we'll be kind of talking through some examples of that today. So there's really, at a very high level, there's three broad ways of protecting ideas that I think of. And it's important to understand that just an idea by itself is not really capable of protection. It's really the expression of the idea. It's when you get the idea down on the paper or some sort of medium that it's really capable of protection. And the three sort of ways that I like to think about this is like a contractual situation. And there's lots of different contracts that exist. These are just a few examples. You can have non-disclosure agreements and assignment agreements and ways to move IP from person to person, or from, like a university to a corporation, all that kind of stuff, right? And then there's sort of legal methods, and there's a variety of different ways that IP can be legally protected. There's, at the sort of the national level, there's the U.S. Patent and Trademark Office for patents and trademarks, and there's the Copyright Office, and you can obtain various types of protections at the United States level. And each state has some of their own protections for trademarks too, and we can mention that just briefly. But IP is a jurisdictional issue, which basically means that, just because you have protection in the United States doesn't mean that you have protection worldwide. And that's one of the sort of early things that starts to happen when people are thinking about what IP they have is, where are they going to be using it? Where would they be disclosing it? If they protect it here, what do they need to do to think about other markets, other places in the global world that we live in? And then practically, it's really important to sort of, from the outset, think about when you talk, to say what it is that you do and not how it is that you do it, right? Because when you're talking to like a customer or, certain investors, it's not really necessarily that important for them to know how it is you do it, because that's some of the secret sauce that makes sense to protect. And so, if you can sort of remember that simple phrase of saying what you do and not how you do it, you're likely to sort of walk a finer path and not step in as many landmines. So let's just talk about some of those sort of, agreements just as a starting point. Most people are familiar with what we call NDAs, or non-disclosure agreements. Very, very common. Sometimes there's one person sharing information. Sometimes both people are sharing information. The difference between that is what we call, unilateral or mutual. And it's important to make sure you have the right type of agreement for the type of arrangement that you're contemplating. Because if you only have a one-way agreement and both sides are sharing information, one side may not have any protection. And that's a really important thing to sort of learn. And there's obviously some standard carve-outs for these types of agreements for information that was disclosed from some other means, or maybe somebody came to it on their own. And so, you have to be aware of what those are. And oftentimes within these agreements, there can be other sort of material terms. And the example that I sort of put here were like non-competes and non-solicitations. So it might say that, you can't, disclose this information, and you can't compete with us. And each contract is really different. So it's important that sort of before you sign any agreement, you really want to make sure that you understand it. And if you have questions about it, that you can talk to somebody who can advise you on what it is that you're actually entering into. When we talk about sort of assignment agreements, I just wanted to give a couple of examples of like the most critical agreements that you typically see when a company is getting formed and people are starting to think about, how to commercialize technology. And that is that, like an NDA, you're actually taking a concept or a sort of an intangible thing, and you're assigning it to the company. And it's really important that when a company is formed, the company owns all of the intellectual property. Because when people invent a patent, if let's say there's 3 people that are the inventors of the patent, all of those inventors, if absent any sort of agreement to the contrary, are able to practice the patent. And so if you want the company to have the exclusive right to practice the patent, you want to make sure that everything gets assigned to the company. And this is really critical when you're going to raise capital from investors, to make sure that, the company owns the important stuff. And this really happens in 2 different ways. The first way is when technology has been developed pre-incorporation. In other words, the technology came into being before the company was incorporated at the state level. And when that happens, that technology needs to get assigned to the corporation. And that's called the technology assignment. And so that really covers everything that has happened pre-incorporation up to that date and then stops. There's a different kind of assignment that you see different names for. Oftentimes, I'm using the term CIIAA, which is Confidential Information and Invention Assignment Agreement. But sometimes you'll see Proprietary Information and Invention Assignment Agreement or variations of that thing. And that's really for the point in time where somebody joins the company and moving forward. So that first one, technology assignment, is rearward looking, and the CIIAA is sort of forward looking. And so what that's basically going to say is that whatever sort of stuff got developed by the founders and by the employees of the company that was related to the company, that's all assigned to the company, and the company owns that. And that's really, really important when investors are sort of looking at, what does the company have, because they want to make sure that there's no leakage from an IP standpoint. And the same thing goes for consultants and advisors or anybody who's creating technology or deliverables that are going to be given to the company, so that it's clear that the company has what's necessary to take the technology forward. And now I'm going to turn it over to Alex, just to talk a little bit about sort of identifying IP and how to start thinking about patents and those types of items.
Thank you, Nate. So I'm going to throw a question out to the audience. In looking at this picture, can somebody identify something that may be patented, trademarked, or copyrighted that is on or in this picture? Feel free to throw it out into the Q&A. Don't make me just stand here waiting, please. All right, iPhone, the computer devices, just about everything, software, keyboard, phones, computer. So those are some of the things that the vertical screens. Okay, so those are some of the responses that we've received. I'm going to throw out, there's that 2-hole punch. There's that little bottle of, it looks like a pill bottle. There are the pieces of paper, the contents on the pieces of paper, the mouse. There's even that plant on the desk could also have been protected. So it just shows you the scope, what can be protected through some type of intellectual property. So next slide, please. Okay, this is another just kind of big picture why patents, trademarks, why they're so significant. This one, it's a listing of the top 20 companies in the United States that have granted patents. And so a company like IBM has over 9,000 patents granted per year, which is a lot. If you look at the names that are on this list, you'll notice that some of the biggest players, some of the biggest companies are on it. So protecting their intellectual property, they take it very seriously. They pay a lot of attention to it. And it's something that is part of their portfolio, part of what they use as their war chest against their competitors, what they use to help develop their products. Next slide. This is another big picture. It shows you globally which patent offices are the busiest patent offices. And you see, well, China, it's right now the busiest patent office. It's overtaken the United States, and the most patent filings are happening in China. United States is still the second busiest by far, but you're seeing globally that people are not only filing in the United States, but they're trying to file in other countries as well. Next slide. Here you see most trademark applications. Again, China is number one, but you're seeing how trademarks are significant, and it's not necessarily the same countries that you're doing the patent filings. So you're noticing countries like Iran is actually on this list. Apparently a lot of trademark filings in Iran. And the reasons for that could be because of the scope of the protection in one country versus another changes. And you may need to look for something that's a trademark protection in one country, which may be covered by copyright in another, and you may have to have an overlap of different types of intellectual property. So next slide. Okay, so we've talked a lot about intellectual property. Nate has touched on some of the contractual ways of protecting it, and he's touched on the 4 major areas, but I'm going to cover them again. There are copyrights, trade secrets, trademarks, and patents, and we're going to go into more depth in talking into each of these areas. Next slide, and over to you, Luis.
Thanks, Alex, and thanks, Nate. And good morning, everyone. So a trade secret is a type of intellectual property, including formulas, practices, processes, designs, instruments, or compilations of information that have commercial value due to the fact that they're secret, not generally known by others. And some of you may be familiar with this type of intellectual property. It does not require registration, or some type of notice to the government. What it does require is that the information is maintained as a secret. One pro to this is because there's no registration required, there's no end date to how long it's in effect. As long as the trade secret is maintained, then the trade secret is going to be there for an unlimited time. A con to this type of IP is that if it's reversed by an engineer, if it's reverse engineered, then the owner of the IP might lose that trade secret. So it may be reverse engineered. So because of that, the owner must take reasonable steps to keep the trade secret a secret. That could include perhaps keeping information locked away in a safe or through some other security measures, sharing the information with others only on a need-to-know basis, and when necessary, using non-disclosure agreements to keep the information a secret. Another con is that the sales and licensing can be complicated. However, all of this, if there is a legal issue which arises, there are legal or state laws under unfair competition that allow for a cause of action for interference with the business of another or an individual's contractual relations and other issues related to trade secrets. Now, if you take someone to court for theft of trade secrets, you'll need to show first that a trade secret exists, and then you'll also need to show that the trade secret was improperly taken through a breach of contract or some other improper means. A few types of trade secrets that you may be familiar with, popular ones, the Coca-Cola recipe is famously kept as a trade secret. Also, KFC's secret blend of 11 herbs and spices. But even things such as client lists for a company might be kept as a trade secret. And things such as an algorithm like Google's search algorithm, also a trade secret. Another type of IP is patents, and Alex is going to talk a little bit about that.
I'm going to start off by saying that there are actually 3 types of patents that one can obtain. There's utility patents, which is what someone normally thinks of when they talk about patents. But there are 2 other areas the design patent and the plant patent. So a utility patent, it's something that's a new or useful process, machine, article of manufacture, composition of matter, or any new or useful improvement. And included in that, you have software that can be covered. And it's really, you're talking about devices, processes, or chemicals. That's covered under utility patents. When we talk about designs, it's the ornamental design for an article of manufacture. So what does that mean? We're talking about really the look and feel of some component of probably a device. I'll give you a prime example of a design patent. Think of headlights on a car. Porsche, for example, very distinctive headlights. They end up getting a design patent for their headlights quite often. Another thing to consider, if you think of the iPhone, there was a huge patent battle, and it was over the design patent, the design of the iPhone. I believe it was the iPhone 4, the iPhone 4 and Samsung, and Apple and Samsung ended up having a global battle, but in the United States, they received an award of $1.2 billion for infringement. So it just shows you that there's power even in the look and of a device. There are also plant patents, which one can obtain, and it's done through asexual reproduction of any new plant variety. It has to be human created, so it can't be naturally occurring. But one doesn't hear that much about plant patents. They do exist. I want to put the idea of design patents as an option for certain types of inventions or certain types of devices that some of you may be thinking of. And we're going to go on to the next slide to talk about more specifically, this is going to refer to utility patents, but many of the same elements apply to the other two as well. So a patent, what is it exactly? Well, it's a right to exclude someone from making, using, selling, offering to sell, importing, or exporting. And what that's done is you get that right in exchange for developing a machine manufacture process or chemical composition that is useful, novel, non-obvious, and disclosed. So what does that mean exactly? Well, I see there's a question in the Q&A.
That's right. We have a question. What type of protection is appropriate for your company logo?
Okay. We're going to touch on trademarks in a couple minutes. And we're also going to touch on copyrights later on. But and I think both of those would be more appropriate for the logo.
Just to add something, when we talk about this concept of disclosing, there's an important sort of step where somebody needs to decide whether they want to patent an item or they want to keep it a trade secret. It's like a sort of a line in the sand. And what's important about that is that if you're going to get a patent, in exchange for the right to exclude others from, making, selling, offering, whatever, you have to disclose everything that, a person who's reasonably skilled in that particular arts would need to practice the patent. And that's from a business standpoint, that's a real important strategic question that shouldn't be sort of passed off lightly. And that's really sort of the very beginning step of when you're starting to think about what IP you have, what bucket does it fit into, and how do you want to think about protecting it? Because at that point you need to say, well, is this something that I want to keep as a trade secret and I'm going to keep it right now as a trade secret? Or am I going to disclose everything and go through a multi-year sort of process of, doing what's necessary to try to obtain a patent. And just wanted to say, just really a very, very important strategic consideration for all entrepreneurs.
It is. It's if you don't want something disclosed, or if you think that it's going to have power going beyond the term of a patent, it's something that as an entrepreneur, you really need to consider. So thank you, Nate. Next slide. So a couple of the other things that I talked about was novelty and non-obviousness. In order to be granted a patent, it has to be something that no one else has created. It has to be, it can't be out there already. So if it happens to be out there in Australia, you can't get a patent on it. If it happens to be somebody has written a paper on it, you can't get a patent on it. And non-obviousness, what that means is, in really broad terms, it means that someone who is skilled in the art, so someone such as an inventor of a device, process, etc., if they look at a combination of inventions or disclosed items that are out there, and they put A and B together, they would look at it and say, yeah, A and B can go together. Well, that's obvious. So you have to really, in order to seek patent protection, in order to be willing to disclose what it is that you'd like to protect, you have to put those considerations out there. Is it already, is it novel, and is it non-obvious? So those are things that you also should think about, and that should be part of the strategic thinking of whether or not you want to seek patent protection. On the plus side, for 20 years of exclusivity, you go through this process. And for 20 years, you can exclude others from, as I said, making, using, buying, selling, etc. In developing patent policy, there's a kind of tension between the incentive. You're trying to encourage people to invent, encourage people to disclose their inventions. But on the other hand, you don't necessarily want them to get a monopoly. So from a policy standpoint, it's always kind of a balancing act. It's a little tougher I don't think we've had a patent monopoly in a long time. Qualcomm is the one that comes closest, but, and they've been through some legal battles over that. But unless you get up to the size of Qualcomm and have such a huge share of the market, it's not something you necessarily have to worry about as an entrepreneur. Another key element, a patent, you don't get any protections from, say, a state level. It's usually you only get the protection if you register your patent or register it with the US Patent and Trademark Office. You go through the process and the US Patent and Trademark grants you the patent. Next slide.
Alex, before we go on, we have another question in the Q&A.
Okay.
From Andrew. What about a unique bundle of services? Each service itself is not unique, but no one else has put these services together in the same way before. Where does this fit into IP universe, if anywhere?
It could depend. I'm going to give you the lawyer's answer. It depends. A lot of it depends on what the services are. A lot of it depends on as I said, the nature of the services. A lot of it also depends on how, say, technologically involved they are. Do you go with a patent? Do you just keep it secret and you say, okay, we're going to offer these things but not tell anyone, which kind of may defeat the purpose. So those are all kind of considerations. You could maybe protect them under a brand, but I guess it would really depend on the more specific services that you're providing. you couldn't actually get a patent on doing some type of human action. So I'll leave that at that, and I hope that's answered your question. So some reasons why a business would try to get a patent. Well, you try to get it so that you can maybe make or use your invention. And what I was saying is that it's a right to exclude. So the patent doesn't necessarily give you a right to make or use, right? It may, but it doesn't necessarily. For example, if you have an improvement on an existing patent that's out there, you're going to have to go and get a license or a cross license with the other party who owns the patent. But having a patent is beneficial because then you can maybe turn around to that other person and say, well, you know what, in order to use your invention, I'll let you use mine. It's something that's commonly done. And you remember that list of some of the biggest players out there who, with the companies with the most patents, they all have cross-licensing agreements with each other. So another reason, a most common reason, is just defensive strategies. You want to exclude others. It can actually help for acquisitions. If someone is looking to buy your company, well, there's a little bit more legitimacy to your company if you actually have a patent associated with your invention. You may want to actually keep your competitors out of the market. So that's another reason. You may not actually have any interest in whatever it is that you're patenting, but it might keep your competitors out of the business, or it might prevent the next step for your competitor. So it could be useful from that standpoint. Another reason to get the patent, well, it's collateral, it's property. You might actually be able to get loans based on how your patent is doing, how your company is doing, and the fact that it has a patent. And another thing is, investors like to see patents. They never want to actually pay for them, but they like to see them when they're thinking about investing in your company. So those are just some of the reasons why you may consider getting a patent or getting patent protection. Next slide.
Okay, so now we'll talk a little bit about trademarks. And a little while ago, we had a question about how to protect a slogan or a brand. And this is the IP that you would want for such protection. Now, a trademark is different but related to other concepts such as perhaps a business name or a URL or a web address. A business name may have a trademark shared with the same name, and also a web address may include a trademark or may have some trademark function, but they're not necessarily the same thing. So we'll focus on the trademarks. And another thing I want to point out is that a business can have more than one trademark. If you have several products coming out from the same business, then you may have different brands, different trademarks protecting the different products or services. Now, if you look at this first slide on trademarks, there's a couple of actual marks or trademarks, brands, logos on there, and a few that are similar to the well-known marks. Alex, you selected these. I'll ask if you want to explain a little bit about the reason why these are up, these particular ones are up here.
Here, just more as examples. Starbucks is an oft-copied trademark, and they've got a trademark on that whole logo, their name, and it's associated with their coffee business. So the other two, Sunbucks and Buckstar, they were taken off the internet. I'm not sure how real they are, but they're more here as examples. So if somebody opened up a Sunbucks coffee, well, you can be sure that Starbucks would be contacting them and sending them a cease and desist letter. Again, same with a Buckstar coffee. To give you a real life example of how that trademark might might come into play. There was a brewery in, I believe, Oregon. They had a Starbucks beer, and Starbucks contacted them and said, you know what, we're going to let you sell out this batch of beer, but you can't make any more and sell it under the name. The idea is because it is similar to Starbucks. It shows it's kind of trying to play on that name, and it may cause confusion with the origin of whatever that product is. So in the case, Starbucks beer. The other two examples that I have here, I'm a big basketball fan. So these are two examples which have come up within the past few years. The Milwaukee Bucks changed their logo to a meaner looking buck or deer, and they got a cease and desist from the company with that logo to the left. Does anybody know what company that is? All right, since we're using the Q&A, I'll let you know that's Jägermeister. Now, Milwaukee Bucks and Jägermeister, would anybody really be confused about that? Yeah, probably not. But the Milwaukee Bucks have concession stands, and they sell a lot of products at their games. So the two ultimately came to an agreement that it's probably something along the lines of the Milwaukee Bucks aren't going to make any liqueurs and sell them under that brand. And I don't think that Jägermeister is going to start a basketball team anytime soon. The other one, the Toronto Raptors and Monster energy drinks. Well, Monster is really protective about that stylized M, that monster looking M. And the claw on the basketball, that raptor claw on the basketball, was what Monster objected to. The Toronto Raptors, they eventually won in a lawsuit against Monster, but the Toronto Raptors have since removed that claw basketball logo from their branding. So back to you, Louis.
Thanks, Alex. The discussion about those battles over the marks brings to mind that in addition to considering the legal aspects, when companies bring those kinds of lawsuits or if these disputes come out in the open, there has to be some consideration for how the public may react. We've seen, just for example, in the alcoholic beverages industry, sometimes a large brewery will go after a small craft brewery, and even though they might be right legally, they might experience some public backlash as the big guy going after the little guy. So sometimes that's resulted in the large breweries taking a softer approach, and they'll draft cease and desist letters that are not too harsh, sometimes even a little funny, just to kind of be, still protect their rights, however, not coming across as too much of a bully. So looking at this next slide, we've got the clear definition there of the trademark. I think we kind of gave a general idea of what that was with our discussion of the last slide. But to summarize, trademarks are intellectual property that are going to serve to identify a source of goods or services. So whatever the brand, the logo, or other trademark you're using, what it's saying to the viewer, the customer, potential customer, is that you're the source of the goods or services under that mark. So that's good for the business because it gives them an edge on competition that may not have the rights to use that or that doesn't have the right to use their trademark or their brand. And it also has a consumer protection type of function, because if somebody's purchasing something that comes under a certain trademark, then they can have some assurances that what the source of the goods or services are, and also what the quality of those goods or services may be based on the reputation of that source. Now, for registering the mark, you can submit an application to the state or the federal government. And one of the things that may come up is whether your mark is confusingly similar to an existing mark. So in that case, you would have a back and forth with the registering office and explain how your mark is different, or at least not confusingly similar to the existing mark. And hopefully you'll be able to come up with some convincing arguments yourself or with the help of an attorney. Another thing to consider is when you're selecting a mark, aside from it not being confusingly similar to other marks, is that the term that you want to register or other item that you want to register, that it's not generic. So if a generic term would be like the word milk for milk products, you're not going to be able to register a generic term because there's public policy that would prevent you from kind of using a word in a way that prevents others from using it in their for its regular meaning. Same is true for descriptive terms. They're harder to register, not impossible, but you'll need to make some arguments regarding the public's ability to associate the mark with the source of goods or services. And if it's a descriptive term, it's going to be more difficult to do. There are ways to kind of cross that hurdle, but it's easier and often more advisable to try to register marks or terms that are either suggestive or, better yet, arbitrary with relation to the goods or services that you're offering. Or you could even make up terms, coined or fanciful term for your product, and that's most often the most easy to register. Gets through the registration process with fewer hurdles. If we could go to the next slide, please.
Yeah, I'm just going to add one other thing. Key sort of strategy thing, when you're thinking about a mark and you're thinking about sort of a name of a company, this is a good time to engage some help to like go out and look at the universe of what other marks are out there to help you understand whether what you're proposing to do is distinctive and whether it's likely capable of registration in the future. And then, as you're developing sort of the name of the company and the brand and buying the URL and doing all the things that you're going to want to do to then invest money into, marketing, it really makes sense to do the advanced research before you start pouring money into things, because it doesn't do any good to, sort of spin up a brand immediately and then get a cease and desist letter 6 months later, after you've already invested time and energy into the marketing strategy behind whatever you're doing. So just want to say, if you're thinking about a name of a company or you're thinking about a new service that you're going to offer or whatever that is, it's really helpful to take kind of a deep dive into what it is that you're proposing to use, understanding what other people are doing, and making sure that, there's kind of a clear runway for how you're going to move forward.
Thank you, Nate. So wanted to talk a little bit about, the fact that you can have a trademark and protect a mark even if it's not registered. So this is not an option, for example, with patents. With trademarks, you can get protection for the mark just through its use in commerce. There's notice that you can provide and a symbol that you can use for an unregistered mark that is associated with goods, and that is the TM symbol. So you may have seen that on packaging for some products, some goods that have a trademark, but the mark is not registered. Similarly, if the mark is associated with a service, you can use the symbol SM, which stands for service mark. Both trademarks and service marks have a similar function or same function. They're often both referred to as trademarks. And then there's another symbol, it's up there on the slide, the R inside a circle, also a symbol you may be familiar with from packaging for goods that have a registered mark. And that R inside the circle may only be used by marks which are registered at the federal level. Okay, so if you get a state registration, which is a possibility, you cannot use the R within the circle. Differences of registered and unregistered mark. A key difference is that the protection for an unregistered mark only geographically only goes as far as the actual use, essentially, of that mark, with some exceptions, but mainly has that limitation. Once you get a registered mark, for example, registration at the federal level, then there's constructive use across the entire geographic region of the United States, even if you're only selling in a couple of states. And that can be an advantage to keep competitors out, especially in areas where your company may be growing in the future, even if it's not actually having sales there of goods or services initially. So one of the key things that you would need to have that registration is going to be the actual use of the mark in commerce. And you're going to need to provide a specimen, an example of how you're using the mark, and some other information to allow for the registration, or at least the review for registration of the mark. With the federal registration, you do have an option that if you have an intent to use a mark, you can file an application with that intent to use, and the mark will get examined and bring it all the way to the point where you get a notice of allowance saying that your mark will get registered. You just have to now actually show us proof that you're using it. And then you have a period of time by which you need to show the government by sending in that specimen that you've actually started use of the mark. So you can start the registration process with the federal government before you're actually using the mark, but to end the registration process, you do ultimately have to show that use of the mark. Now, if there's an option to use a mark with registration, and you could use the mark unregistered, why would you spend money to do and effort to do the registration process? Well, I mentioned, for example, that one benefit is you get that additional extension of the geographic scope where your mark has some enforceability, but also in litigation, you'll have certain other presumptions that will cut your way if you have your mark registered. You may be able to get an increase in damages. So the money in damages that would be paid to you if you brought a lawsuit would likely be higher if you had a registered mark rather than an unregistered mark. If we could go to the next slide, please. And actually, yep. So here's a few examples of word marks. So we've got Apple, Google, Netflix, IBM, and NBC. And you want to point out that Google that's sometimes used as a substitute for the word to search for something. Just a word of caution and I may have mentioned it earlier, when a word is generic, it's not registrable. And what happens sometimes is a mark becomes a household term, like Kleenex, for example. It's a well-known word that is for a brand of tissue paper, but it's become such a household term that now it's used to refer to tissues generically. Any tissue is a Kleenex. Xerox is another term that is a trademark that some people use generically to mean copies because it's a household term. When a mark starts to become used as a generic term, there's a danger of what's called genericide, meaning that the trademark will die and will no longer be able to be used as a trademark because it does not serve its function as an identifier, as a source. Just something to consider. Also, something I want to point out with these word marks, these are very famous marks, but you don't have to have a famous brand to register or to use a trademark. We do a lot of work with startups and individuals who have a mark that they want to register, and those can be registered just as well as some of the more famous marks. And on the next slide, we just have some images, also very recognizable for the most part. I want to point out that you can register words and images or designs. You can do the full color designs, or you can do a black and white version of it to protect it differently. And more broadly, there's things such as sounds that can be registered. So like the NBC chimes are a recognizable sound, have been registered. The color pink, for insulation has been registered. So like the Pink Panther type insulation or brand insulation also has protection for that color. And you could see if somebody would see that insulation, they'd know almost from the color immediately what the source was that produced that product. That is an overview of trademarks. And next intellectual property we're going to cover is copyrights. I believe Alex is going to discuss that.
Before I jump into copyrights, there was a question. It said, you mentioned Coca-Cola and KFC as examples of companies having recipes famously kept as trade secrets. Are there circumstances where a recipe or formulation can qualify for the stronger protection of a patent? So there's one thing that I want to touch on, the kind of interplay between the trade secret and the patent. One of the things that I should have, or I may want to add for patents, is that there are what are known as statutory bars. So for example, if you come up with a device and you offer it to sale or for sale, or you show it to investors, well, that means that clock starts ticking and you have a year in which to file a patent application. So if you've been selling this device and you've been selling it for a few years, that actually can bar you from seeking patent protection. So one of the reasons with trade secrets, after a while, you have to maintain that trade secret status, and you have to put in efforts in order to try and keep it secret, because you can't get a patent. So there could be chemical formulations that someone can come up with that they may want to eventually seek a patent on, but they could be time barred from doing so. So that's a reason it doesn't normally rise up to qualify as a patent, but you would choose one or the other, or you'd keep aspects of your invention. For example, I think the algorithm for the search that Google performs, that was mentioned. That's something that you'd keep secret. Or for example, specifically if you have ingredients in some type of formulation, you may want to disclose the ingredients and disclose some quantities that you want to protect with the patent, but you may keep other steps in your process secret, right? So there are reasons to do both, and there are reasons why you don't necessarily want to go with one to try to get to the other. So I hope that has answered that question. Okay, moving on to copyrights. So a copyright, it exists for an original work of authorship fixed in any tangible medium of expression. What does that mean? Well, just by virtue of writing down, say you have a fantastic poem that is going through your head and you write this down on a napkin. Well, you have an original work which is fixed in a tangible medium of expression, that napkin being that tangible medium of expression. So just by virtue of doing that, you can get a copyright, or you have a copyright. The copyright is something that comes about by just putting pen to paper, fingers to keyboard. You can actually get some type of a copyright protection. However, it's an unregistered copyright. And things to think about in the unregistered versus registered copyright scope. You get one just by virtue of coming up with it and putting it in that tangible medium, but if somebody infringed upon that, if say you're doing this at a Starbucks coffee shop and you've written things down you've written things in your computer, and the person at the table over looks at your computer, sees that, and starts publishing that on social media. Well, if you have an unregistered copyright, then you would have to show first of all, show that you are the owner of that copyright. And then secondly, you'd have to show how you've been damaged by having somebody else infringe upon it. And those are two pretty high hurdles that you have to clear in order to get damages. Another thing is, for unregistered copyrights, you would be filing things in state court rather than in federal court. So the process is slightly different. If you register your copyright within a specific period of time from creation or from publication, there are different time intervals, then you would end up getting statutory protection for your copyright. And you could end up getting statutory damages, so that I think people have heard about the $120,000 or $125,000 in damages for every infringement. Well, that's something that could be covered under the statutory damages, right? Next slide. So, next slide. So if you register in a timely manner, another thing that you end up getting is you could potentially end up getting attorney's fees for infringement. So there's a real incentive to go and register your copyright with the Copyright Office because of those protections. Another thing that I want to throw out here, there's what's known as fair use. And fair use is normally a defense against copyright infringement. It doesn't necessarily protect you from being sued for infringement, but it's a way that you can defend yourself and say that, okay, I have a right to use someone else's work. And a lot of times that comes into play where it's non-commercial. So if you're using it in a non-commercial manner, then you might have fair use protection. If you transform elements of the work that you've taken, there isn't really a hard and fast number to this, but if you've transformed 90% of it, chances are that it's transformative enough. If it's 10%, well, probably not. Things like satire and say comedy routines that borrow someone else's work, those could be protected. And these are all, as I said, defenses. So it wouldn't necessarily prevent you. You see this on YouTube a lot. Somebody puts up something that is, say, a picture or a video of their kid doing something really cute, but it's got some type of music in the background, and they get a takedown notice. Well, they turn around and they would say, well, this is fair use. I'm not making any money off of it. Well, on Google or on YouTube, you are making some money for views. So it ends up falling into the commercial category. And is it enough that somebody can actually sue you for copyright? Well, maybe, maybe not. So the question of fair use comes into play a lot when as a defense, but it doesn't necessarily protect you. So I see that there are some questions. Does anybody have? We seem to be doing really well for time. We've got a lot of time for questions. Because I think this is the end of the presentation. Yes.
Well, like we have that clarification question in the Q&A from Molly again. So to be clear, recipes and formulations, or in other words, combinations of consumable items can be patented. There's nothing to exclude those types of items per se, except the strategic decision-making of the company, perhaps.
Yes.
So, folks, are there any other questions that people want to raise for the team here to discuss? If not, I think we're going to end a little bit early just to give time back to everybody. But really have enjoyed talking with you guys today and getting a chance to talk about an area of the law that's really exciting for us. If there are folks that have things that they want to talk about offline, feel free to reach out to us. We can put our contact information in the Q&A before we sign off here, and our feel free to give me a call at 607-272-0800 as well. I think there's one other question that may have just popped in here.
Two, I think they're starting to trickle in now.
Starting to trickle in, so let's not hop off quite yet.
You want to read them, Sarah?
Yes. First one from Alex. From a practical standpoint, if I'm Apple or GE, I'm going to patent everything because I have the strength to defend that patent in court. If I'm a startup, how does that change?
Really good question and really important consideration to this goes back to what Alex was saying about the right to exclude others from practicing the patent, not necessarily like a right granted to use something. And the reality of the situation comes down to sort of money and resources. You might have a patent, but if you don't have the resources necessary to go to federal court and prosecute somebody for sort of infringement, then there's a serious question about what the value of the patent is for you. There are absolutely some financing resources and other firms that engage in support for some fights if there's a really strong case or a good reason or that kind of thing. But all things being equal, if we're talking about a pre-revenue startup that's starved for cash, the ability to really go about somebody is definitely in question. I mean, the cost of a federal lawsuit, even if it barely goes anywhere, is absolutely insane. To use the technical term. So I would say that that's part of the analysis that often people are asking themselves of, do I patent this? Do I trade secret it? Do I do this? Do I do that? It's one of resources and what are you able to do and how do you intend to use it going forward? I don't know if you want to add anything, Alex or Luis, on that.
I just wanted to say, yes, it is very much a balancing act. It's a question that startups have all the time. But I think the issue when it comes to future licensing, when it comes to just getting your idea out there, your ability to talk about the idea, seeking patent protection over the main inventive concepts is something that you should really consider because it helps that you don't have to sign non-disclosure agreements with absolutely everyone. If you go to present your invention, you don't have to, you can actually go to a conference and present it. So those are things to think about as well. What about the growth of my business? You're not necessarily thinking about just protecting and the fear of, well, what happens if some giant company infringes upon my product? Well, you might actually have ways of keeping them out, right? And it may turn around that you're enough of a threat that they may just turn around, rather than suing you, they might just buy you out, which is something I think a lot of entrepreneurs would be quite happy with. Go ahead, Louis.
Yeah, I'll also point out that you may not have to defend or enforce your patent on your own if you are in some type of strategic alliance, maybe with a licensee, or if you assign the patent rights to someone who has the deeper pockets and is willing to do those, do the patent battles. That may also be another option to consider.
I think there was a follow-up to that also from the same person who posted. I think it was Alex who posted the first question. Would I be more likely to favor trade secrets if I can't afford to defend a patent in a lawsuit anyway? Possibly, but usually you're relying on growing your business, and chances are, the reality is that a lot of these big companies, they pay attention to what's being patented, right? But they also, until you become interesting or large enough to affect what they do, you're not really going to be noticed by these big companies. For example, someone like Apple, right? They make their products. They make a lot of money making their products. They make a lot of money doing what they do right now. So the idea of someone coming up with a circuit or something that would change the way that Apple does things, or that would change everybody else and be a significant improvement on Apple, it's really small that you're going to get noticed. So you're always balancing, what do I want to do to grow my business versus how afraid am I that the big fish are going to notice me, right? And usually right now at this stage, you're more concerned with growing your business than fighting off lawsuits. That's something for down the road.
Our next question is from Norma. What about publication? How does this restrict your right to patent/trademark/copyright? And there's a little bit of context too. We had a graduate student interning for us. We were surprised to see an academic publication pertaining to our technology. We were not consulted prior to publication. We would have liked to have an opportunity to seek patent protection.
I'll add, there's a follow-up to that question as well, is there not? It's related.
Just a bit of context, I believe.
Okay.
Can you repeat the question one more time, Sarah?
Yep. What about publication? How does this restrict your right to patent, trademark, copyright?
So was it published by the person who was the inventor or published by somebody else?
It was, the follow-up is, we had a graduate student interning for us. We were surprised to see an academic publication pertaining to our technology. We were not consulted prior to publication. We would have liked to have an opportunity to seek patent protection.
That's a real problem. And one in which, you know, if you're running a lab and you're, you know, sort of bringing students into the lab and they're getting access to information that, you know, you consider to be proprietary or confidential in some nature, there absolutely should be some sort of agreement with those that are working in the lab as to, you know, any disclosures that they're going to make concerning, you know, proprietary or confidential information. And, you know, if that's one of those where, you know, we're happy to discuss particulars offline, but it, you know, whether it's a lab or a company or an organization or whatever, the concept of their wanting to be protections around things that anybody considers to be confidential or proprietary is one where agreements are really, really important. And I would encourage anybody who's in that environment, you know, academic, non-academic, whatever, to think about both, you know, contractual agreements and or sort of handbooks or policies or statements around what people can and can't do with the stuff that is considered to be proprietary or confidential in nature.
I want to add to that. It's a really significant. It's really significant that people think about any type of employment agreement, even with an intern, and they're really, if you're a startup or if you're any company that's dealing with things that you want to keep secret and don't want everybody to know, you need to have some type of non-disclosure within your employment agreement. It really has to be there. It's something that you really need to think about, and you should think about early on as people come on board, as you contact suppliers of parts, as you contact potential distributors, as you you may turn around and say, well, I need a machine shop to make certain parts for my device. You may need a non-disclosure agreement with all of those. So I hope that at least answers part of that question. Another thing to think about with the publications is timelines. So timelines can affect it. If it's within the timeline, you may still be able to patent or seek some type of protection. But as Nate said, if there are more questions, it's probably something, or if there are more specific questions, it's probably something we should take offline.
All right, well, we have a couple more questions, one from Jonathan, one from Christina, but following up with the NDA, I'm going to ask Alex's question. Also, from a practical standpoint, how commonly are NDAs used? I sometimes talk to entrepreneurs who want me to sign an NDA for an initial meeting, and that seems in most cases unreasonable. How do you suggest inventors and entrepreneurs use NDAs sensibly?
So let me kick this off, and then we'll get additional comments from Alex and Luis. You know, as I started the conversation, we talked about sort of those three big categories, right? One is sort of legal, like the contractual protections, having agreements, that kind of thing. Legal protections, you know, things like the Patent and Trademark Office and places where you can go register work. And then the sort of practical consideration of how you talk about your stuff. And the reality of the situation is there's places where it's totally appropriate to have contractual agreements. And Alex was just mentioning some of them: employment arrangements, vendor arrangements, anything like that. That's the sweet spot for an agreement. And there's also places where it's entirely inappropriate to have an NDA. So the example of that would be the first meeting with, you know, a venture capitalist who likely talks to 1,000 different companies a year, and you know, they're just not going to sign an NDA, and you're wasting your time and basically showing that you don't really understand sort of the role of the company and the role of the investor by asking. And so that really means that, like, it's crucial if you're in a place where an agreement makes sense, great. If you're in a place where an agreement does not make sense, that's where it's so important to think about how you talk about what it is you do, right? Because, you know, you can talk about what your technology accomplishes at sort of the end of the technology, but you really don't want to get into disclosing the secret sauce, even if they're inquisitive, because at least on that initial meeting, it's just not the kind of thing that rises to the level of needing to open the kimono and show everything that exists. And so, you know, it's not an easy line to always walk. There's obviously some gray areas here, but I just kind of wanted to highlight some areas where people, you know, where it makes sense to have a contract and where it doesn't, because, you know, that's absolutely one of the challenges of being an entrepreneur, is knowing sort of what's appropriate in various different circumstances. Alex or Luis, do you want to add anything to that?
Yeah, I just wanted to add that in addition to knowing when might be the right time to propose an NDA, you know, and oftentimes that may not include the initial introductory meeting. Also what's in the NDA, how long the NDA might be, and, you know, a one-page NDA may have a different impact or different use than a 5 or 10, you know, 5-page NDA, let's say. And so to that point, you know, be wary of just picking up a document off the internet and bringing it to a meeting. You know, just to plug our services a little bit, it's always good to have an attorney review whatever document you're going to be asking a business ally to sign off on.
I'm going to throw out one other thing. So we're talking about things that you want to keep secret under the NDA, right? And the original question came up because things were in development. If one of the things that I would advise, it's not necessarily always possible, but before you're going to disclose anything publicly to, say, an investor, or at a conference you're going to give some type of presentation, we try to recommend, if it's an invention, that you get at least what's known as a provisional patent, and that's a type of patent application where you submit your disclosure at the very least. So all you have to do is submit the disclosure, and it gives you a year kind of leeway before you have to submit a full patent application, right? So the idea, this is what I tell a lot of inventors, is if you're going into meetings with investors or VCs or anyone that you're going to be sharing your invention with, that you try and get some type of patent protection at the very least, so you can at least say, look, as of this date, I had this invention and I'm going forward with this patenting process. So that's one thing that I'd really urge businesses to consider, or urge you to consider in the startup process. So be ready before you're actually talking to investors, and protect what you can before disclosing it. I know it's not always possible. In an ideal world, you'd be doing what what I was just saying, but it's not always possible. You're always balancing, okay, I don't want to disclose too much, with I need to disclose, right? It's just the nature of the game, and there isn't 100% clear, bright line.
Yeah, I 100% agree with Alex on the concept of provisionals. In reality, they're not that expensive to file. And because there's no prosecution on the other end, because you're kind of in that 1-year period, it's one of those things where literally, if you knew that there was a big conference that you wanted to go to and you wanted to make a presentation, and you needed a week to get it together, you could probably do that and get it filed and move forward. Like, it's a relatively quick and cheap process, and one that carries with it a lot of benefits. And so, going back to the classic case of the lab where the grad student came in and then published the paper afterwards, it's not unreasonable that if somebody worked in a lab that they wanted to publish something about it, in theory, But what should have happened is there should have been, an agreement so that there's, no sort of unauthorized disclosure. The grad student comes to the professor and says, hey, I want to, do this paper. Will you consent to that? And that makes it an authorized disclosure. And then, you go ahead and file a provisional and then say, yep, go ahead and publish the work. That's the process for how that same fact pattern could have been resolved very, very differently. And everybody would have gotten what they wanted without sort of anybody getting hurt in the process. And that's an excellent case for a provisional in a situation where somebody doesn't want to publish a paper.
Great. We have a question from Christina. Where do mobile apps fall into this? Are there a lot of matching apps / dating apps that have the same swipe functionality or gaming apps? A lot of the games are the same aside from the logo in need of a trademark. Would there also be a patent or copyright with any of these?
You guys want to go first?
So my take on this is software, the actual code itself can get protected by a copyright. So by virtue of just putting that code in, you have a copyright. The downside is that really only protects you from exact copying or pretty close to exact copying. With apps, usually I think you would try with the trademark, and you would protect certain, I guess, elements, maybe look and feel of the app, maybe logos, maybe any slogans which you have. Those are things that I would think of off the top of my head. If there's something more specific, like if your app is falling more into the lines of, hey, I'm improving the way that a phone works, then that's kind of moving over into the line of, all right, we should maybe seek patent protection on it. So really all three have come into play here: copyrights, trademarks, and patents. And then there's always just keeping quiet about what's going on underneath your app.
One of the other things that's challenging about apps too, and I guess software for that in general, is that there's a lot of open source issues and like things that are out there where people are developing an app, but they're using sort of a platform that was created to do that. And so there's an open question about truly how proprietary or novel is it. And so it's really kind of needs to be on a case-by-case basis. It's really hard to make generalizations about software or apps or things like that, just because you have to do kind of a deep dive into exactly what was created and what else was borrowed or open source or something like that.
We haven't even touched on open source. Open source is just a whole other can of worms. And other than what Nate said, just being aware of what's open source, if you're using open source elements and your ability to protect those, read the contracts, read whatever open source agreement it's created under. You have to read it and find out, because it may end up coming back to bite you. So read it. If you don't know, consult someone who can help you out with that. Ideally consult an attorney, but just understand that contract. Don't just plunk some code out there and say, oh, it's open source, and then try and protect the app. So I'm going to stop there, because as I said, this is a whole other presentation.
Thanks, Alex. That being said, if anybody has ideas for future content sessions, anything they'd like to see, drop your ideas in the chat.
Well, we've really enjoyed being here, folks. I hope that, you got something out of the presentation. Sarah, if you could drop our contact information into the Q&A, just so people have it, if they want to follow up on other matters, that'd be super helpful. And then, like I said, if anybody wants to continue the conversation, just give us a buzz. We'd love to chat with you. Alex and Luis live in Rochester. Our office in Ithaca here is over on the inlet. I'm often on campus a couple of days a week. So, hopefully we'll run into each other in the future, and, look forward to possibly working with you in the near term. And with that said, I guess we're going to wrap up here, and hope everybody has a great Friday.